Hare Krishna. Welcome to Tax Guru YouTube channel. This is CA Rohanar Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. And today we are going to conduct a special video on a topic GST show cause notices alleging suppression but without any specific allegations or evidence. So let's dive into it. Let me allow to share my screen. Yes, so GST show cause notices alleging suppression but without specific allegations or evidence. So today's topic is extremely relevant in the GST landscape. Over the last few years, we have seen a large number of GST notices where serious words like fraud, willful misstatement, or suppression are used almost mechanically. In many cases, these words are simply lifted from the statute without explaining what exactly was suppressed, how it was suppressed, or why it shows intent to evade tax. So this creates two major problems. First, it exposes taxpayers to extended limitation and harsh penalties without justification. And second, it increases what? Litigation unnecessary. So today we are not discussing how to evade tax or defraud revenue. We are discussing how the law expects allegations of suppressions to be made, proved, and defended in line with the rule of the law. So let's start with our first slide, understanding legal framework. Let us first understand it. Under GST, invoking extended limitation or higher penalty is not automatic. The law clearly says that this can happen only when tax has not been paid by reason of fraud, willful misstatement, or suppression of facts with intent to what? Evade or with intent to evade tax. So these are not decorative words. They are conditions that must be satisfied before any action like suppression. The department must prove each element, what was suppressed, whether it was material, and most importantly, whether there was an intention to evade tax. Unless this burden is discharged, extended limitation simply cannot apply. So moving further, let's understand the meaning of suppression. Suppression means deliberate withholding of material information which the assessee was duty bound to disclose and with intent to evade tax. So court have consistently held that a deliberate and conscious withholding of information which the taxpayer was legally required to disclose is what we can say as suppression. It doesn't mean a difference of opinion, it doesn't mean a wrong classification, or it doesn't mean a dispute on interpretation. If the taxpayer has disclosed the facts in returns, books, audits, or in correspondence, then there is no suppression at all, no matter how strong the department's views on taxability may be. So moving further, means one also keeping these points that mere omission, wrong interpretation, accounting error, classification dispute doesn't amount to suppression. Next, value show cause notice. A common defects observed what mere production of statutory phrases, no identification of exact suppression fact, date or period of suppression, mode of suppression, absence of relied upon documents, conclusions stated as allegations. So one of the biggest problem we face today is vague show cause notices. Many notices simply say you have suppressed facts with intent to evade tax and stop there. But what we have suppressed, tell us. They do not tell us which fact, on which date, or by which act. This is legally unacceptable. A show cause notice is not a conclusion. Please note down or understand it. A show cause notice is not a conclusion. It is the starting point of adjudication. If the foundation itself is weak, the entire proceedings collapse. So that needs to be very carefully seen whenever we received any show cause notice. Moving further, let's understand principles of natural justice. So, natural justice is not a technical argument. It is a constitutional principle, and we can say the fundamental right of a taxpayer. If a notice doesn't clearly tell the taxpayer what he is accused of, how can he defend himself? So, vague allegations deny the taxpayer a real opportunity of being heard. Courts have repeatedly held that such notices violate the basic fairness and cannot be sustained. So, impact of violation is denial of effective opportunity and entire proceedings liable to be quashed. Moving further, let's understand extended limitation. Extended limitation is an exception, not the rule. In GST, we are in a system where returns are filed online, data is auto-populated, audits are conducted, and information is also available with the department. So the question we must ask is, how can there be suppression when the department already has the data? Very important. So the question we must ask is what? How can there be a suppression when the department already has the data? So knowledge of the department is knowledge of the state. Once facts are available on record, extended limitation cannot be invoked. Please note down this. Knowledge of the department is knowledge of the state, and once facts are available on record, extended limitation cannot be invoked. So returns, auto-population, audits, e-way bills, and department intelligence systems weakens what suppression claims from the department. Moving further, let's understand the penal consequences. Penalty is not automatic. If suppression itself fails, penalty collapse automatically. You cannot punish someone unless you first prove it that there is an intent to evade tax or intent of fraud or intent of culpable mind. GST may be a civil tax statute, but allegations of fraud and suppression carries serious civil consequences and must therefore meet a higher threshold of proof. So in next slide, we will see important judicial principles. In Pushpam Pharmaceuticals Company, suppression must be willful and deliberate. Mere failure to disclose is what insufficient unless intent to evade tax is established. In Cosmic Dye Chemical, extended limitation cannot be invoked unless positive act of suppression with intent to evade is proved. In Anand Nishkwa Company Limited, when facts are known to both assessee and department, suppression cannot be alleged. Univerth Textiles Limited, misinterpretation of law or classification disputes doesn't amount to suppression. Please note down, misinterpretation of law or classification disputes doesn't amount to suppression. So in Continental Foundation joint venture, burden of proving suppression lies with whom? Entirely on the department. Please note down this also. Burden of proving suppression lies entirely on the department. Mere inference is insufficient. So, in several landmark judgments, it has been held that suppression must be willful and intentional. Mere omission or interpretation disputes do not qualify as suppression. These principles were laid down long before GST and continue to apply today because the language of the law remains the same. Moving further, let's understand practical defense strategies. So we must, what are the key action points we can take as a professional? Challenge the, means as a professional or as a taxpayers to challenge the jurisdiction to invoke the extended period, demand what disclosure of evidence, demonstrate that disclosures in returns, books, audits already, argue absence of intent, and then seek dropping of penalty and limitation extension. So these are the key action points. If you want, you can take a screenshots of the slides for your ready reference in future. So moving on to the conclusion part. To conclude, suppression is not a routine allegation. It is a serious charge. So vague notice harm what not only taxpayers but also the credibility of the tax system. GST was designed to be transparent, predictable, and fair. As a professionals, our role is to ensure that law is applied with discipline by both the taxpayers and tax authorities. So strong revenue collection and strong legal safeguards are not enemies. They are the partners in mature tax system. So that's it for today. Thank you. Thank you so much for patient hearing. Please note down my contact numbers, email ID, and if you have any observations, suggestions, queries, questions, then do let me know. So you can also comment below the video if you can. So thank you so much. If you are not yet subscribed to Tax YouTube channel, then do subscribe for latest updates and video series like this. So bye bye, take care, see you soon. Hare Krishna.